document, and it immediately can be used by the agent. These are very powerful documents. So you always have to be mindful of the fact that of who it is that you're selecting, and knowing that if you give them immediate access to your financial matters, that they can use the document and go into a financial institution and have access to your funds. The other type of power of attorney, much less frequently used, is something called a springing power of attorney. And that's a power of attorney that springs into effect when a doctor certifies that you're not competent to take care of your finances. Those documents can be very difficult to use. We rarely use springing powers, primarily because financial institutions dislike powers of attorney. They want to be able to work with their customers directly. And if what we're putting in place now is a situation where the power can't be used until we have a certification from a doctor that you're not able to that you're not competent to handle your financial affairs, and we now have to take that physician's letter together with a power of attorney and send it to a financial institution, there's going to be an extraordinary delay in an action being able to be taken relative to your finances. Yet the power of attorney is extremely important to have. Without it, you're left facing potentially a guardianship proceeding in New York, which is an application to a court where somebody would seek to be appointed your guardian. And it could be somebody it could be a family member, or it could be somebody off of a list that the court holds, where you'd be having an individual who you do not know or did not know overseeing your financial affairs. So having the power of attorney where you're designating who it is that you want is absolutely critical. I get asked a lot as relates to powers of attorney, gee, why do I need a power of attorney if I have my account owned jointly with another person? Because that person who's jointly on the account can also access the assets and work on behalf of a person if they be of the co-owner if that person became incapacitated. And the answer is there's a couple of reasons why. One is if you put somebody jointly on an account with you, you have now given them a right of inheritance to those assets. With the power of attorney, you're merely designating someone who has an access to act on your behalf and manage your finances, and that access can be easily terminated at any point in time. But if you add somebody onto your account, you've really, and these accounts are referred to frequently as joint accounts with rights of survivorship. You've probably seen bank accounts, they say JTWROS, and that means joint with rights of survivorship. And at the time of your passing, those funds will, whatever is in the account, is going to go to the surviving party. And sometimes you may have a will, for example, that states, let's say that you had 3 beneficiaries and you were leaving to those beneficiaries in 3 equal shares, yet you had a joint account with one of them, and you passed away. The party who's the joint owner with you is going to get paid first, and may actually wipe out the interests of the other parties. In other words, if you have a joint account, that trumps anything that you have in a will. A will controls assets that are in your individual name. But if you have a contractual arrangement through a joint account, that trumps the terms of a will, and it may not have been your intention that just one party receive those assets, because your will is indicating, well, 3 people should be receiving the asset, yet you had all the assets in a joint account with one person. So having the power of attorney negates that sort of a circumstance. The other reason with powers of attorney is to not have a joint account is in circumstances where you might have an estate that is above taxable limits. If you were to pass away, whichever party passes away first is considered to be the owner of all the assets, which would make them subject to estate tax, and that is something that you also would want to avoid. So powers of attorney are extremely important documents to have. You're really at a loss if you don't have one, and you should become incompetent. And what I'd like to do at this point, just so that you see what a power of attorney form looks like, if you can go to page 143, where the power of attorney form is located, and maybe we can pop to that on the table of contents here. I think if you click on where you see power of attorney down towards the bottom of the table of contents, you'll see the New York State, we're looking at it now actually, the New York State power of attorney form. And this form has been in place now for the past 10 years. Let me back up a little bit more to the first page of the form. But what it does, it allows you to appoint multiple parties. You can appoint as your agent one person, two people, and you can state how it is that you want them to be able to act. You can name one person and have a backup to that person. You can name two parties and authorize them to act independent of each other, or you can authorize them to have to act jointly before any action can be taken. So you can do all sorts of different things in the power of attorney form to make sure that that you're appointing parties who can work together, or that many times people will appoint two people who have rights to act independent of each other, and that is an arrangement frequently used because it's very flexible. One party's available, they can act. If that party's not available, the other party can act. But of course, you have to be comfortable with the individuals who you're selecting, that they can either work together or not work against each other when they're acting on the power of attorney document. Things to consider in the power of attorney document, you're actually looking at the part of the power of attorney document that addresses this issue, is when you're signing a power of attorney, and let's say you made it a power of attorney that really allows someone to have full oversight and access to your assets. And that's frequently the power of attorney that's used. It gives people unfettered discretion to manage your assets. One aspect to financial management is gift giving, and whether you should allow the person that you've appointed as your financial agent to also have the right to make gifts of your assets to other individuals. Now, that's giving somebody a lot of power, and what you're looking at right now is the gift rider to a power of attorney. Sometimes clients are not comfortable giving them that much authority, but I caution you, because the initial reaction to giving somebody the right to make gifts of your funds is one where you might tend to cringe a little bit. But I'll tell you two primary reasons why that's very important. Again, in the tax arena, it may allow for reduction of tax liability if you are able to have somebody who can gift assets away from you. And also in the arena where we're doing elder law planning, and we may have a situation where a party is maybe applying for the Medicaid program in the future. It's so important that you allow your agent in the power of attorney to be able to make gifts away from you, because the limit that the total amount of assets that you're permitted to have in order to qualify for the Medicaid program is only $15,000. Currently now it's just went up to $15,900 of non-retirement assets. You're actually allowed to own retirement assets and still qualify, but non-retirement assets can't total to be more than $15,900. And that may require the agent being able to gift the assets away from you so that you can qualify for Medicaid, or sometimes when we're dealing with taxable estates, it would allow for your agent to transfer and gift assets away from you so that you would be below taxable limits. So very important to consider the use of the gift rider in the power of attorney document. The other thing I want to alert you to is, and this is really kind of hot news off the press, or at least hot news in my world, is that Governor Cuomo signed legislation within the last 30 days authorizing a new power of attorney format and document. The power of attorney document that is in the materials and is what we call the New York State statutory form that must be recognized by all financial institutions is going to be replaced by a new form, effective, and that form hasn't even been put together yet. The legislation that was passed and signed by the governor will be effective starting June 13th. So the point of my telling you that is that we don't even have the form for that document yet. It hasn't been created, because this law has been passed only very recently. It will be very similar to the document that you see in the materials. It won't have a separate gift rider. Instead, the gift rider will be internally contained within the power of attorney document without having to have this separate rider. But it's essentially going to be very similar. And powers of attorney to be effective, they need to be signed by 2 independent witnesses, and also to be notarized at the end in order to be effective. So that's the financial document that's really key while you're alive. And the healthcare documents that are so important to consider are the healthcare proxy document, which if you turn to page 91 of the material, if we can bring it up on the screen, that is the document where you're appointing somebody to make your healthcare decisions for you if you cannot make them yourself. So it's limited to a circumstance where you can't make them yourself. With the power of attorney, if you remember, I said, well, that can be used immediately, even if you're competent, unless you use a springing power of attorney. But the healthcare proxy is almost like a springing instrument in that it cannot be used unless it's been confirmed that you're unable to make your own healthcare decisions. And if we could push ahead to the next page of the healthcare proxy, I think it's the instructions now that you're looking at. But you have it there in the materials. You can go a few pages forward. And what you'll see is a healthcare proxy form works a little bit differently than the power of attorney. Here, under the public health law in the state of New York, you can only name one person as your primary agent, followed by a successor, and you can have multiple successors, but no 2 people can be acting together in a healthcare proxy document. The document is there just to determine who it is that you want to make your healthcare decisions if you can't make them yourself. Public health law doesn't want to have 2 people with equal authority to be able to handle healthcare matters in the event of a dispute. So the law states that you have one person named and succeeded by another. Healthcare proxy documents, they are in effect indefinitely unless you specify a certain limited amount of time that you want it to be operative. I generally don't encourage your doing that. You can always terminate the document at any time, but I've seen situations where clients will write, this healthcare proxy will be effective. They know that a surgery is occurring or some procedure in a hospital, and they limit it to 30 days or 60 days or 90 days, and then they neglect to ever re-execute the healthcare proxy, and the person ends up with no document at all. There is a body of law in New York that's existed now for about 10 years. If you do not have a healthcare proxy and you are not competent to make your own healthcare decisions, New York State does have the Family Healthcare Decision-Making Act that does exist. And there the state has prioritized a schedule of people who have priority to be able to make those decisions for you. And it's usually a spouse, followed by children, followed by other relatives. And it includes, it's actually a pretty comprehensive list, but it may not be the party that you would want to make healthcare decisions on your behalf. So you're much better off executing the healthcare proxy on your own. If you want additional people to be able to be involved and have knowledge about your healthcare, the status of your healthcare, you can sign a separate HIPAA release form, which allows other individuals to get medical information about you, although they are not the decision maker. But by their being able to also get information, they could perhaps confer with the actual healthcare agent who is the decision maker, and perhaps help them in terms of making decisions that way. Or it's just a thing to do where to say, perhaps you name one child as a healthcare agent to allow the other children to at least have access to medical information for their own benefit and knowledge, or to assist your sibling perhaps in making the decision. Two other documents in the healthcare arena. One is called the living will statement. And that's unlike the healthcare proxy, which is your designation document, the document where you're designating somebody to make your healthcare decision. The living will is for individuals who want to state a preference that in the event they were ever in a persistent vegetative state, that they would not want to be kept alive by artificial means. And a living will statement is a confirmation of your wishes in that regard. If there is no living will statement, your healthcare agent can still make decisions about withholding or withdrawing life support. But if that's challenged, then you're going to end up with a hearing in court to determine what it is really that this person wanted if they were in a persistent vegetative state, which could have been avoided had there been an instrument that they signed confirming that fact. The last document and most current document in the healthcare arena is a document called the MOLST form. MOLST stands for Medical Order of Life Sustaining Treatment. And there is a whole section in this publication that talks about MOLST, and the MOLST form itself is on page 104. You can take a look at it, and this is a document that's used. It's frequently used, certainly for people of more advanced age, where they want to be making certain declarations very clear, such as it includes you can say, I do not want to be resuscitated under certain circumstances, that you do not want to be intubated. It has a DNI order on it, and it states certain wishes that you have in terms of how you're to be cared for. But the real important piece of the MOLST form, and it is the O letter. That's the order. This is not only signed by you, but it is also signed by your physician, making it a medical order. And these can be very effective documents. I've seen them used over the years. They've only been in existence in New York State, and it's now about 15 years that they've been around. I still find that many people are unaware of them. Your primary physician is certainly aware of them. And if you were to contact their office and say, I'm interested in signing a MOLST form, they generally have a member of the staff in the doctor's office who would sit with you, go through that form. You could sign it, and then the physician could countersign it, and you effectively have a medical order. So it's something to be aware of, and kind of another document in the healthcare arena. I want to swap now to the area of general planning, the area of wills or trusts. And here we're talking about under what circumstances we want to use a will. I think most everybody is familiar with what a will is. It's a disposition of your assets at the time of your passing, directing to whom it is that you want them to pass to, and in what percentages you want people to receive those assets. Or do you want to use, instead of a will, do you want to consider using a trust? And a trust is an instrument which is really an agreement. A trust is an agreement between you, the one who is creating the trust, and that person is usually called the grantor, the creator, the settlor, the trustor. As soon as you hear that or person, you know that's the person who's setting up the trust. And they enter into an agreement with a trustee. Sometimes they can be their own trustee. And it sets forth how assets owned by the trust are to be managed when you're alive. And talks about how the trust can go on to say how your assets are to be managed at the time of your passing. Trusts can act as a substitute for a will. Whereas a will is really only dealing with your affairs at the time of your death. A trust is dealing with your financial assets when you're alive, and it can continue to speak at the time of your death, similar to how a will speaks as to how those assets are to be distributed among your beneficiaries. When do you use a will? When do you use a trust? And it's a matter of personal preference, but there are some times where using a trust, it kind of cries out for using a trust. Circumstance where I generally will encourage clients to at least consider using a trust is a circumstance where they own real property in multiple states. So they have a home in New York, perhaps they have a home on the Jersey Shore, they have a place in Florida, in Arizona, whatever it may be, they own real estate in multiple states. And the reason we look toward the trust for that is because the law states that you must probate a will in every state in which you own real property. And that starts to become very burdensome if you have to do that in multiple places. So sometimes what we will do is just deed all the real property into a trust, and that will avoid the necessity to have a probate proceeding, at least as relates to those real estate assets. Another time that we might think about using a trust instead of a will is if you're leaving your assets to your beneficiaries who are not your next of kin. Or sometimes I've had clients, many times actually over the years, who do not know who their closest relatives are. If you're in a circumstance like that, you need to understand how a probate proceeding works, how a will would have to operate in the environment where you're not leaving assets to your closest relations, because what the probate process requires is that even though you have the absolute right to not make any provision for children or grandchildren, even though you have that right, the probate proceeding would require that your closest relatives who are not receiving anything still be notified and given a copy of your will and an opportunity to object to its terms. And certainly, if you're not making any provision for that person, slowing down the probate process that way makes the use of a trust much more desirable. A trust, which owns, if in ownership of your assets, you don't have to have a probate proceeding that involves the surrogate court. In New York State, we call the probate court the surrogate court, and there's one in downtown White Plains in Westchester. And when you are involved in a probate proceeding, that is the court that the will is submitted to and reviewed by the judge. And if in fact closest heirs are not receiving assets, those heirs are going to need to be notified and given an opportunity to object. Of course, objecting by saying, gee, I really don't like the fact that dad left all the assets to my sister and not to me, doesn't really cut it. Okay, you have to have a real legitimate objection, such as saying, Dad was not competent when he signed the will, or Mom was under duress by another party when she signed the will, or something along those lines. And it is very, very difficult to overturn a validly signed will. But the probate process is one that, if you're involved in a circumstance where you're not leaving your assets to your closest kin, and you think those kin are not going to be particularly happy about the fact that you've done that, sometimes people will use a trust, which is a more private instrument, does not require court supervision to settle, and they will look towards the use of a trust in that circumstance. Other reasons for using a trust as opposed to a will. A trust, as I just mentioned, is a private document. It allows for confidentiality if that's particularly important to you. A will, once filed with the court, is a public document. Anybody in the world can go and read it. And another reason that trusts are popular with many individuals is that, as I mentioned before, it can be used during lifetime, and that you can kind of put all of your assets into a trust, have the terms be, and we're talking now about a trust that's a revocable trust, one that you can change and modify and alter just like you can with a will. So it can easily be changed, and you can be your own trustee on a revocable trust like that. And then when you pass away, the trust will go on, like a will would go on, to distribute the assets out to whoever it is that you want, but there won't be any court oversight on that. It's a private instrument, and the settlement of estates with a trust can be much quicker than they can be with a probate process, particularly one where you have people who are likely to be contesting your will. So it's just important to understand what the probate process is. What is subject to probate are assets that you own in your individual name that do not have a beneficiary. So if you have an account, like a retirement account, where you have a named beneficiary, that's not part of probate. Why? You pass away, your beneficiary is now going to receive the asset, and that trumps the terms of a will. You could write in your will, I want my retirement account to go to my daughter, yet on the beneficiary form, you had it going to your son. The beneficiary form is the controlling document. It's a contract, it's a controlling document. Same thing if you own assets jointly, which we spoke about all the way at the beginning of our discussion. And there again, one party dies, that asset's not subject to probate. Why? Because the asset was held joint with rights of survivorship. It automatically, by operation of law, passes from the deceased party to the surviving party, irrespective of what the will says. So those assets that are just in your name alone, that do not have a beneficiary, those are the assets that are subject to probate. And those are the assets that sometimes people will contemplate placing into a trust, because that takes them out of probate. So they may have some assets that are in their trust. They may have some assets that have beneficiary designations on it. They may have some assets that they own jointly. But in all of those circumstances, those assets are not subject to probate. And that's when you're analyzing, gee, should I be using a trust or I should be using a will? Those are some of the factors to be considering. The type of trust that I've been alluding to, as I mentioned, is a revocable trust. There are also irrevocable trusts that exist, and they come into play mostly for tax savings purposes, because now you're putting your assets into a trust irrevocably. You will generally, on an irrevocable trust, you're not going to be in control of those assets necessarily. And there's tax planning that is used in that arena. You'll see a lot of frequently used irrevocable trusts to own life insurance. and irrevocable trust that own residences, and many of those are set up for estate tax reduction planning purposes. The other primary reason that you'll see an irrevocable trust, because this is now the area I want to touch on and start to conclude the discussion and open things up to questions, is using an irrevocable trust comes up in the arena of long-term healthcare planning, again, where a party might be considering qualifying for the Medicaid program. Assets that somebody takes and puts into an irrevocable trust, well, those assets are now you have given them away. Like, you can make a gift to a person directly. You can make a gift by placing assets into an irrevocable trust. You have irrevocably given them away from yourself. And after a period of time has elapsed, the assets that you have moved away from yourself, whether it's directly to someone else or placed in trust, those assets, after a period of time have passed, are no longer considered part of your available resources if you were applying for Medicaid and they were to take a look at what assets that you own. And in the Medicaid arena, we're now talking about rules that apply as follows. Many of you may be familiar. You've heard the term, gee, it takes 5 years and before you can qualify for Medicaid in a nursing home. And that is correct. From the time you transfer assets away to the point that you have no more than $15,900 of assets, of non-retirement assets in your individual name, there is a 5-year delay in eligibility. Home care services, as we sit here today, do not have a penalty period associated with the transfer of assets to qualify for home care. However, legislation has been passed that will take effect. It may take effect on April 1, although now it seems that the governor's office is pushing this back to July 1, which is a bonus. But once the April 1st date comes or the July 1st date comes, whichever one it is ultimately going to be, and the general consensus is it's going to be July 1, transfers of assets to qualify for home care Medicaid for the first time in the history of the state of New York will have a penalty period associated with it. It will be a 2.5-year penalty period, 30 months, but it will exist, which means that, focus on doing this sort of planning as early as possible. It should be contemplated because the way planning frequently would work out is that where people didn't do their planning up front, most people preferred to have care at home. They would transfer their assets. They could become eligible for care at home on a virtual immediate basis. And then the assets have been transferred. The person's cared for at home, and they kind of hope that they'll get through number one, they hope that they'll never have to go to a nursing home, or if they did have to go to a nursing home, that more than 5 years will have passed from that point in time. The Medicaid arena is a very complicated arena. Usually the primary asset that families are looking to protect is the family residence. So I just want to focus on that for a moment so that everybody just knows what the options are related to the ownership of a family residence. Because in the Medicaid world, when you gift it, not just in the Medicaid world, the thing to understand about gifting, and gifting is important, as I said before, tax reduction, and in the Medicaid area, when you gift away assets, your original purchase price of those assets, such as a residence that you may have bought 40 years ago for $100,000, that's now worth $1 million. When you just give that asset to somebody else, they get your original cost basis, the original purchase price. And when they resell it, there's going to be a capital gains tax on the difference between, if it was sold when it was worth $1 million, and the difference between $1 million and $100,000. One big break that the government gives related to planning of this sort is something called stepped up tax basis. And that is a benefit that all taxpayers in the United States are given, but unfortunately you have to die in order to get this benefit. And the benefit is that if you have these low cost basis assets that you purchased 40, 50 years prior to your death, that are now worth 10, 15, 20 times what they were when what you paid for it, they are, when you die, if you own them, the cost base is stepped up to the fair market value of the asset on the day that you died. And your heirs, your beneficiaries, will inherit the assets at the fair market value on the day you died. And if they sell it in close proximity, where it hasn't appreciated more since you died, there'll be zero capital gains. That's a huge difference. However, if you're owning the asset in your own name, you could say, well, why not just own it in my own name? I pass away and I get the stepped up tax basis. That's true, but you haven't moved the asset away from yourself, so you're not going to be eligible for Medicaid. So the answer there is an irrevocable trust, which I referenced before. And that's the type of trust where you've put your assets in there irrevocably, given them away from yourself. However, you are permitted to retain an income interest in that sort of trust, and you're also allowed to retain an interest so that you can change the beneficiaries of that type of trust. And by keeping those sorts of rights, the tax law says that that sort of irrevocable trust will also get a step up in tax basis at death, as if you own the assets yourself. So for Medicaid purposes, a trust like that, an irrevocable trust, works because you've moved the assets away from you. But for tax purposes, the IRS, the New York State Department of Taxation and Finance, treat it as if you still own the asset. And that's exactly what you want, because you want to have the step up in tax basis. I welcome you to go through this, the publication that you have a link to. It's about 150 pages plus exhibits with tons and tons of information and resources that you can connect in terms of helping you with respect to this sort of planning. And with estate planning and elder law planning. And with that, I'm going to conclude and open up the floor to questions. Kaidi, thanks for your help.
All right, thank you, Mr. Stephen Schurkman. Anyone have any questions? You can raise your hand. Let me see if there are any hands up. Okay. Tanya, please.
Yeah, hi, this is actually Jeff, Tanya's husband. I have a couple of
Tanya, you have questions?
Yes, I do. This is actually Jeff, Tanya's husband.
Hi, Jeff.
Hey, how are you?
Good, thank you.
That's good. So I have a couple of questions just on a irrevocable trust. If a right to live commitment, so, can you place an asset into an irrevocable trust and then not have your trustees, in effect, kick you out of your dwelling?
Thank you. And I know I didn't place you as a shill in the audience, so that's a great question. And the answer is, I always counsel clients this way because that's frequently one of the first questions they'll ask, which is you can retain, when you set up an irrevocable trust, a lifetime right to reside in the residence, such as it's referred to as a life estate interest, and nobody can put you out. So the answer is you can do that, and the irrevocable trust will still operate. And that's usually how they are set up, in fact.
Oh, okay, terrific. And sorry, one more question on that theme. So do you need to own the property outright in order to place it into a irrevocable trust?
You mean not to have a mortgage on it? Is that what you're referring to? Okay.
Yeah.
The answer to that is if you are transferring a property that has a mortgage on it into a trust in which you have a continuing interest, such as a life estate interest in the property or a right to continue to receive income back, because sometimes instead of a house being placed in the trust, somebody puts their brokerage account in there, they're allowed to get the income back on that. And that is permitted and is not a violation of the mortgage instrument. So that's okay.
Oh, okay, terrific. So in order to do that, you would set up a trust first and then look to,
Right.
potentially transfer.
You're right. You could contact the bank and alert them to that. And there'll be a lot of paperwork to process that way. Or you could just continue to pay your mortgage. And if the bank, was all of a sudden to become aware and say, gee, what, you transferred your ownership interest to this trust, you can just give them a copy of the trust and say, I really transferred it to an entity that I still have a control feature on, and therefore it's a legitimate transfer, not in violation of the mortgage instrument. Okay.
Oh, terrific. Can I actually ask one more question just on? I don't mean to hog everyone's time, but the final question is is a trust considered a business? So can you potentially, purchase assets against the trust, using them on sort of trust behalf, like vehicles, home office expenses, and write off against tax base?
If it's a revocable trust for income tax purposes, okay, since you can revoke, now I'm not talking about the Medicaid type trust that we were just talking about before. Now I'm talking about the most common trust that you'll see is a revocable trust, which means you can set it up, you can be your own trustee, and you can do whatever it is that you want to do as if you own the asset in your single name.
Mm-hmm.
There, you don't even file a separate tax return for the trust. That type of trust is called a grantor trust, meaning that you as the grantor are in control of that trust. You're entitled to the same sort of income tax benefits as if you own the asset yourself.
Okay, great. And irrevocable trust, is that?
Irrevocable trust, depends. The type of irrevocable trust that we're speaking about in the Medicaid context, frequently people will file a separate income tax return, although it is also a grantor type trust, and will still entitle the person to the same sort of estate and income tax benefits that you would have if you own the asset yourself. But there are other irrevocable trusts where that is not the case, and the trust would have to file its own separate income tax return. And trust income tax rates are much, much higher than an individual's income tax rates. So I caution, when you start to enter this arena, you need to work with a qualified tax consultant, whether it's your CPA or a tax attorney, to make sure you know what you're getting into.
Okay, that is so helpful. Thank you.
Sure, my pleasure. Okay.
Anyone else have questions? Or you can unmute yourself.
IT, there is a question in the chat box.
Oh, I see. Okay, let me see. Okay, Stephen, it's from Ann Casapini. Are documents of legal Zoom valid? Like, for instance, a will that is notarized.
Okay, be very careful with documents coming off of LegalZoom or a similar company. The documents may be fine. Okay. In fact, I'm sure that they are fine, provided that they're executed correctly. And this question is a perfect example of what would not be a properly executed will. So sometimes people think you just notarize something and it's magical and it's valid. A will, however, is not notarized. A will has to be witnessed by at least 2 independent parties. And that may be spelled out in the instructions that LegalZoom provides, but if people aren't carefully reading those instructions, they could really be in a bad place. They'll have no will at all. Okay. I see if I could respond to the other chat question I see here. It just says, what is considered a retirement asset versus a non-retirement asset? Because I said retirement assets you're allowed to own and still qualify for Medicaid. Non-retirement ones you cannot own and over $15,900 and qualify. A retirement asset is an IRA account, a 401k account, a 403b account, a 457 account, any sort of qualified annuity. In other words, tax-deferred assets are the types of assets that are exempt in the Medicaid world. You're allowed to own them and still qualify. They present sometimes issues on the income side, which are not ideal, but they're still better than the non-retirement assets, which disqualify you entirely. Okay, and I'm just looking in the chat box. I don't know that I see anything else here. I do not. Okay. If anybody else would like to ask a question, please don't hesitate.
Yeah, sorry, I have one more question. I guess just regarding, I guess just regarding trustees for a irrevocable trust. So if you set up an irrevocable trust for your family, can one of your, like, how do you set the, because I guess you as the grantor in an irrevocable trust can't be the trustee.
Not in an irrevocable trust, yes, but in an irrevocable trust, the grantor cannot also be the trustee. So generally, and when we're doing Medicaid planning, if that's what's happening, what you'll find is that the parent, of course, is the grantor, and they grant all of their assets into the trust, meaning they transfer their ownership into the trust. The trustees are commonly the children who are permitted to be the trustees. The income interest in the trust can remain with the grantor, meaning they can get paid back interest and dividends from the assets they contributed to the trust. But the actual principal asset that went into the trust, meaning the corpus, not the interest and the dividends, that is locked away from them. They do not have access to that. That's the irrevocable asset that they put into the trust that's no longer available to them. That's how the irrevocable trust works. But the children do have access to the principal. They are allowed to take the principal out of the trust. They cannot give it directly to their parents. However, they can pay for expenses of their parents with those funds. And that's how the principal sometimes is accessed.
And I guess if you had 2 children, then you would need both would need to be in agreement to make any alterations or remove funds from the.
That's correct. Right.
And is that post the age of 18, or is that?
I'm sorry, do they need to? Yeah, the trustees have to be 18 years of age or older.
Okay, perfect.
Okay. All right. Yeah, the trustees are the ones in charge of making decisions about home maintenance, etc. They are also the ones who have to sign documents in the event of a sale of the home. However, they can't sell the house out from under the parent, as I mentioned, because the parent still has the lifetime right to live there, unless the children are able to find somebody who will buy a home where after they come home, where after the closing, they go back to their new property and find somebody who has the right to, is having lunch and has the right to be there for the next 20 years. So usually it kind of blocks any transfer of the home, because there aren't a lot of people who really want to buy a home where somebody's still has the right to live there for the rest of their life.
Mhm.
And there's another question from Joseph Amaraso. Is it true that in New York State, an irrevocable trust can be changed to a revocable trust, and why would one to do that?
It would be difficult to, you can modify and amend an irrevocable trust and just, terminate an irrevocable trust, or change it into a revocable trust. I can't really think of a good reason why you necessarily would want to make it a revocable trust, but it's possible to do that under a section of the law that says if all interested parties in the trust sign an amendment or sign a termination of the trust, then the irrevocable trust can be terminated that way. But the problem sometimes with all interested parties are, number one, there may be multiple parties. And if the parties don't all agree to terminate the trust, you need unanimity. It's not like majority rules here. This is New York state law. It's all interested parties. Sometimes people will leave their assets to a child. If the child's not alive, it goes on to the grandchild. If the grandchild is a minor, they can't consent. And sometimes you can get stuck in circumstances like that where you can't amend, or modify the irrevocable trust. But you can if you get all parties to agree to do it.
Thank you, Stephen.
Sure.
Anyone else have question? We can take the last one. Okay.
Well, actually,
okay,
I see one in the chat box here. I think.
Yes.
What is the best way to leave? What is the best way to leave assets to children? Oh, just lost it. No. What is the best way to leave assets to children rather than a second or third spouse, or children of a second or third spouse, especially for a late life marriage? The best way to leave assets to children rather than a second or third spouse. Okay, got to be just one thing to alert people to generally here, and I didn't mention this. I didn't mention millions of things actually, but one thing I didn't mention is that spouses, if so, when you get late in life marriages, prenup, okay, because under New York law, if you don't have a prenup, you cannot disinherit a spouse, even if it's your fourth or fifth or sixth or seventh spouse. You can't disinherit because they have something called a right of election. That means they're allowed to take 1/3 of the assets of the deceased person, even if the deceased person left them nothing. Okay, so the first thing I would say to this person is, before the parties get married, make sure they enter into a prenuptial agreement where that right of election is waived. Okay. I think that I don't.
Thank you very much.
Okay.
So I also want to mention that there is a Westchester Library System. They always has this annual event. It's collaborate with Senior Law Day Collaborative Project. If you want to, actually, Stephen was always who is one of the speakers over there for the Senior Law Day. And if you want to know more information, you can go to www.seniorlawday.info. So you can learn different kind of topics from there about elder law or a lot of issues related to seniors. So thank you so much, Stephen, for giving us a very thorough and updated knowledge. Very appreciated. So
my pleasure.
I guess, yeah, okay. And also welcome everyone to join the program today. And if you have any questions, you can always send me an email. And if you have any suggestions about the programs, you can always send me an email as well. And hope next year maybe we can invite Stephen to come back to give us another section for updated knowledge.
It'd be my pleasure to come back anytime.
Okay.
All
Thank
right,
you,
everybody.
ma'am.
Have a good evening.
Thank you so much, Mr. Schurkman.
Okay. Bye now.
Thank
Very
you. That was
informative.
terrific.